Yes, sir, Mr. Waters.
Thank you, Chief Justice, and may it please the court. I'll start out by saying, and again, I'm not going to, unless this court would like me to go through the extensive facts that were presented here, but fundamentally our case boiled down to 4 important points. Number 1 was motive, and I know we'll talk about that, and I believe that the motive was very compelling here, and we'll go into that. But the motive pointed to Alex Murdaugh. Number 2 was the means to commit this crime. And what the evidence showed were 2 family weapons were used to commit this crime, both of which could not be accounted for after the crime was over with. Number 3, opportunity. And this was huge. That timeline that was very detailed that, frankly, the defendant tried to use to be exculpatory actually was very inculpatory and showed that not only was he at the crime scene with the victims just moments before they died, but importantly had been lying about that to anyone who would listen. And that evidence was particularly strong when you look at the fact that when we look at that kind of evidence, we look at patterns. And what was also so important about him being there is that his phone showed no activity, as Justice James mentioned, from about 8:09 to 9:02. And then from 9:02 to 9:04, he had 283 steps, far, far more than he ever had in any comparable period during the review period that we had. So you had that evidence of opportunity showing that he was the one who had the opportunity to commit these crimes. And then finally, you had multiple acts of guilty consciousness of the various things that he told law enforcement and all the rest of it. So that's classic case. It may have been a long case and put it all together, but it boils down to basic, good old, how do you determine who did somebody? Motive, means, opportunity, and acts of guilty consciousness. And I think the evidence was very strong with all of that. We started with the cell phone evidence, and I'll go to that as well, since that's what counsel started with. And I want to start out by saying, first of all, that this is clearly not preserved. I'm going to talk about that very briefly because, as Chief Justice Kittredge pointed out earlier, this was an old school judge. You got old school lawyers, old school prosecutors, and Judge Newman made it very clear at the beginning of this case what he expected with objections, that they be timely and that they be specific, okay? So this is not a case where preservation is a gotcha moment. This is a case where the judge was very clear about what he expected with that, and the parties that were trying this case are ones who understood that very well. So I think if there's ever a case to look at error preservation issues we've raised throughout this brief, this is that case to do that. But beyond that, let's look at what happened during the defense case. They called an expert who, Mr. Surgis, who is a former North Carolina deputy who has digital forensic examiner training in Cellbrite and Apple, and he was qualified in cell phone forensics. And while he was on the stand, he used an unidentified iPhone with an unidentified iOS operating system to demonstrate for the jury that just a general motion will cause the raise to wake feature to turn on. And they emphasized that over and over again, that all it took was a gentle motion. Just a gentle motion is all it took. And they did that demonstration on the stand. And so the state, in reply, called a deputy who had extensive training in digital forensic examination, same exact training, who was qualified without objection in the same exact cell phone forensics. And what was more important here was he was here to correct fundamentally what was a misleading statement from the defense examiner, because what he knows, and he knows how these things are programmed, he knows how they work, and the implication that if only a general movement will turn it on, that necessarily a more violent one like slinging it like a frisbee will turn it on, is false, because the phones are designed and programmed, the accelerometer in there are programmed so that while a gentle, normal motion when somebody wants to look at their phone will trigger it, violent motion will not, so that your phone's not constantly coming on when you're jogging or running or doing anything like that. People don't look at their phone like that, okay? And so the phones are designed to do that. So he did the exact same thing that the defense examiner did, except for he did it much better, because first of all, he used the exact same model iPhone. He used a similar iOS version that was used, and he manipulated it multiple times in many different categories. And it was there to ultimately disabuse the notion that if it comes on gently, it necessarily is going to come on when you sling it, because it just doesn't. And that is how iPhones work. And so when he was in cross-examination, and Mr. Griffin did a great job of cross-examining him, and at one point he says, well, I don't know anything about anybody else. Well, maybe that was an inopportune answer, but that's not the end of it, because he went on after that to testify, I have expertise in how cell phones work. I can tell you about the knowledge C databases. I can tell you the ways iPhones, the software is written, what kind of code it's written on, and I can tell you how data is stored on it and the program that's involved in it, the programming that's involved in it. And frankly, his testimony proves the point, because he made sure that the jury understood that just because a gentle raised awake, a general motion will trigger the raised awake, doesn't mean that a violent motion will do that. In fact, it's more likely that it won't, and the phones are designed specifically to do that. That is an expertise that is beyond the knowledge of the average person. And again, this is not one, I think, as we talked about before, where you need to apply the counsel factors and all the rest of it. When you're talking about sort of an experiential type of testimony, the ultimate test is reliability. And he had the same exact qualifications, the same background, and was qualified in the same manner.
But his testimony was sometimes it does, sometimes it doesn't.
That's correct. And that's the reality of how it works. Because again, these things are programmed to react to different types of inputs, and it's not an absolute guarantee. But the point that was important about that was that just because a gentle motion might turn it on doesn't mean that a violent one would. In fact, it's more likely that it won't, because the phones are programmed to do that, and like throwing it like a Frisbee.
This is probably not relevant to much, but why this phone being taken from the scene, and why not Paul's? Why not just leave hers there too?
Well, that's very interesting.
Was there any, I know, is there evidence, I think there's evidence that it was raised to wake at some point and put back down.
Yes.
So that was at 9:02, 9:04, something like that?
Correct. So the evidence, if you look at that timeline, and I could go into it in great detail, but what the evidence showed and what the reasonable inferences from it was, number one, Alex had Maggie's passcode. He did not have Paul's passcode.
You might need to stick closer to the mic.
I apologize. All right. So he did not have Paul's passcode. Paul's laying face down, and his phone is laying just on the outside of his rear end, outside of his pocket. And in fact, the defendant told police that he picked up the phone, or he tried to turn Paul over, and the phone just popped out. Okay. But what's interesting about that is what's so crucial about the time of death and the forensic timeline, as we called it, establishing that time of death, is that Paul was actively in a conversation with his buddy, Rogan Gibson, and that's who the kennel video was for. But he never completed that conversation, and both Paul and Maggie's phone go silent forever and ever, amen, at 8:49, about 30 seconds apart. Well, Rogan continues to try to contact Paul, all right? And so when we look at contact on Paul's phone, there's somebody who actually looked at it, and the backlight came on, which is indicative of somebody, the Face ID, not recognizing who it was. But as we know, those phones will display like messages coming in. And very interestingly, Alex Murdaugh, in the wake of the brutal murders of his wife and son, yeah, he calls his brother, but then before he starts calling all these other family members, he's blowing up Rogan Gibson's phone. Okay, so the inference is that he saw that, he can't get into Paul's phone, but he's concerned about Rogan. The other inference is that he takes Maggie's phone with him, because we see steps on her phone, and we also see activity of the orientation changing, and that orientation will only be logged if the backlight is on. And so when he gets back to the house, that's all of a sudden when his phone comes alive. From 9:02 to 9:06, there are 283 steps, but at the same time, we're seeing orientation changes, and he is calling Maggie's phone. In fact, we can see an orientation change 2 seconds before the call comes in, which is certainly susceptible to the inference that whoever's calling is looking to see that call come in, like somebody who's manufacturing an alibi, like somebody who tells the police in his first interview, look at my phone, I was calling Maggie. He calls her multiple times while he is running around like a chicken with his head cut off, and then jumps in the car. And even though he said that Maggie came home because he asked her, or she was worried about him, and Marion Proctor testified that Maggie came home to go visit Miss Libby, after all of that, and he's blowing up her phone, he doesn't take the 100 yards down to the kennels to drive by there. So again, not to argue the facts, but all of this was very indicative when you look at this timeline of Alex looking at Paul's phone, leaving it there, taking Maggie's phone, taking it up there, start manufacturing, making sure those calls are coming in, and then as he's leaving out in a haste, he's leaving out of the Moselle, slinging the phone out on the road. And the reason why the backlight, there wasn't an orientation change for that is because the backlight didn't come on, and that was the point of McManigle's testimony.
I'm not asking you specifically, I want to change gears to 404. I'm not asking you specifically in this case, because I know you believe your motive is very plausible. But in general, how plausible does motive have to be? I mean, could a prosecutor want evidence in and work backwards from there? How does a trial judge analyze that?
Well, I think that the trial judge is fundamentally the gatekeeper and ultimately has to analyze that under the 404 test, which is it relevant? Is it fall under an exception? Is there a logical connection? Is it clear and convincing? And is it, the 403 analysis? I think that.
So not just the evidence you're trying to admit as motive, but the motive itself has to go through a 404 analysis. Is that what you're saying to me?
Well, I'm saying that the evidence that's being presented, every bit of it, yes, has to go through that and be part of that 404 analysis. But I think here, and I'll talk about this, that there's an unbroken chain, and that's why the extent, which it was extensive, but there's a reason why, and it wasn't overkill, it wasn't cumulative. But yes, the trial judge is absolutely the gatekeeper for that. Now, what we did here, and I think this is the best practice, is we wrote a detailed pretrial motion and laid it entirely out, wrote out every bit of it, wrote out the entire theory, and put that out for the defense and said, Judge, defense, this is what we're planning on doing. And in opening, I was very careful. I just said there's going to be things going on in his life. I didn't talk at all about that. And then we did the in-camera hearing, and we were very careful. And before I even broached those subjects, I raised that to the trial judge to ensure that the entirety of that was being considered.
Was there any 404B that was disallowed?
There was. So there was 404 of evidence of an affair that Marion Proctor and Maggie's concern about affair that he excluded as too remote. And then there was a side of the road and narcotics evidence, but ultimately that eventually came into play because of opening the door.
Was there any 404B related to financial crimes that was disallowed?
I think no, but I think that
That's what concerns me, and I want to just gently push back and give you an opportunity to respond. Yes, the judge is a gatekeeper. Unlike the federal counterpart of 404B, our case law has said that our version of 404B is a rule of exclusion, not inclusion.
Right.
And the gate here was just left open. And I couldn't find any example of financial crime evidence that was excluded. And the granular detail in the expansiveness of which everything under the sun was allowed is arguably problematic. Even the nature of the victims, there are many examples here, and I want you to respond, so I'll just share one. I think his name is Tony Satterfield,
Right.
was testifying. Well, we had to hear about the disabled brother. How is that relate to motive evidence? That appears to be that not only is he a thief with a motive for murder, he's a despicable, low-life character. I mean, the very evil that 404B is designed to prevent, and then ultimately 403 as the final safeguard.
Right. Well, first of all, I'll say that this was never argued nor presented as propensity evidence, and frankly, this court has recognized, and other courts have recognized, that the less likelihood of propensity when there's a vast difference between the type of 404 crime and the crime it issued. You know, once a stealing white-collar lawyer, always a wife and son murderer. That's never was the inference and all the rest of it. Satterfield was independently relevant, and we streamlined this inquiry intentionally, and the defense made their general objection to the 404, but never did, once we kind of crossed through that door, we presented all of that in camera, never made any specific, like, limit this part, limit that part. We tried to streamline it all. The only reason Satterfield was a witness who testified specifically was because Satterfield was one of the factors in the gathering storm. Satterfield, of course, there had testified that appellant had reached out to him and that he had reached out to appellant in the months leading up to the murders, I think even in June of 2021, asking about the case and about the settlement. And Alec, of course, is lying to him and saying, yeah, I'm still working on the case, I'm still going. But the reality is that he stole almost $3.4 million and had spent it 2 years ago.
But what did one of the Satterfield children's status as mentally disabled have to do with any of that?
Well, I think the point of that was just sort of the background of how Alec had interacted with them and how this was a family that was close to him.
Did the fact that the young man was disabled add to the fact that he stole?
I think what it added to, again, was we had a witness who was testifying for independent purposes, and that was just a background fact of the pressures on Alec, because he had taken this family under his wing, a family who had one individual that he had told, I'm going to help you, I'm going to take care of you, one of whom had special needs. He had spent all of that money. They're asking questions about it.
The sympathy directed toward the victims of the crime is not related to the motive. If he's a thief, and that was the motive for doing it, this extraneous information that tugs at your heartstrings is not related to that. And like when I asked you the question earlier, you responded by immediately segueing back to the financial crime itself.
Right.
Not this extraneous stuff of every granular detail
Yes, sir.
of his acts of theft.
Right. And I will just say, in putting that in, that was just, we had a witness testifying, that was part of the background information that witness testified to, and that, again, it was part of his interactions with this family that was part of the pressures, one of a myriad of factors that were all coming to a head in June of 2021.
If you had condensed your theory of motive,
Right.
the whole gathering storm thing, down to the essentials and left out all the stuff that the Chief Justice and Justice James were talking about. In my view, you could have done that in about an hour and a half or 2 hours. You took 12 and a half hours to do it. So then you're taking that condensed version, you're presenting it to the judge to try to establish a logical connection. This is following up on something Justice Verdon asked, and also asked the same question of Jim Griffin.
Right.
What is the level of inquiry that the trial judge goes into to kind of get to the legitimacy of the theory of motive? Obviously, the jury would be the ultimate decision maker on that, but to what extent should the trial judge question whether it's a valid and legitimate theory of motive?
Well, I think that the words of the logical connection are there, and I think that as far as the trial and the clear and convincing nature of the evidence, but I think as long as it is a passable theory of motive and that motive is logically connected to the underlying crime, then ultimately, as you say, it's for the
in all the cases that that I think we've looked at this logical connection question, it's been either easy, yes, there's a logical connection, or easy, no, there's not one.
Right.
Here, it's not easy. It's debatable, right?
Your Honor, I would say, and if you'll permit me, I'll go through why these are all connected and why this is a unique situation, and it demands, it's a complicated situation, and